Good afternoon, everyone.
Members of the media, public protector staff, with me today. As you may be aware, nearly 2 weeks ago, an event that could potentially bring our esteemed judiciary into disrepute and one that should worry all democracy-loving people occurred when Advocate Andrew Breitenbach SC received a controversial text message from a person who has since been identified as Mr. Ismail Abramjee. Advocate Breitenbach is the lead senior counsel for the Speaker of the National Assembly and the chairperson of the Parliamentary Section 194 Committee in an application I have brought before the Western Cape High Court in regard to Section 194 process. He received this text message on the eve of the proceedings in the Western Cape High Court, where he was going to argue on behalf of the Speaker and the chairperson of the Section 194 Committee against my application for an interim interdict, barring the Speaker, the chairperson, and the President from taking any action or steps in the Section 194 process pending a decision of the Constitutional Court. The Chief Justice Raymond Zondo is due to issue directions on my application to the Apex Court to rescind, reconsider, or vary the decision which was made on the 4th of February 2022, ruling on the appeal application brought by the Speaker in respect of my earlier victory in the Western Cape High Court, where I had successfully challenged the lawfulness, validity, and constitutionality of the parliamentary rules upon which Section 194 process is based. On appeal by the Speaker and the DA, the Constitutional Court dismissed the ground of unconstitutionality based on the denial of legal representation, but upheld the separate ground about the appointment of a judge to serve on an internal independent panel of the legislature. So in the text message concerned, Mr. Abramjee informed Advocate Breitenbach SC that he had it on very good authority, in fact open quotes and close quote, that the Constitutional Court had reached a decision in respect of my rescission application. Mr. Abramjee spoke with authority in his text message, stating that without any apparent fear of contradiction, that the Constitutional Court had already dismissed my application and that his decision in this regard was to be published before Friday last week. He concluded that the message, with emphasis that he shared the message strictly on strictly confidential basis. Naturally, my legal team and I were alarmed and disturbed by this unfortunate turn of events. We found it regrettable, and we have raised it as well with the judges and everyone. So it is so inappropriate that Mr. Abramjee's conduct was also brought to the attention of the full bench of the Western Cape High Court, consisting of Judges Erasmus, Dolamo, and Veli, agreed that the proposal of all the parties in this case, except the DA, that this matter be postponed to the 18th and 19th of May, while we sought to get to the bottom of this matter and refer the matter to the Chief Justice. And if there were still any lingering doubts about the enormity of this transgression, the head of the judiciary and the Constitutional Court, Chief Justice Zondo, has since announced the launch of an investigation into the matter, and following the letter which the parties wrote. It must be clear that this was as a result of all the parties involved. So we wrote that letter as the applicants to the Chief Justice, and the Chief Justice has acknowledged and is investigating the matter. It is against this background that I came here today to lay criminal charges against Mr. Abramjee and one or more as yet to be identified persons whom I have reason to believe are based in the Constitutional Court. The criminal charges arising out of the alleged leak include contempt of court, defeating or obstructing the course of justice, and contravention of sections 3 and 8 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. Section 3 deals with general corruption relating to any person, and Section 8 specifically deals with offences in respect of corrupt activities relating to judicial officers. This leak, if established, clearly poses a threat to the very fabric of our democracy, the rule of law, and much needed independence of the judiciary. The country therefore has no choice but to get to the bottom of this matter. It cannot be swept under the carpet. It cannot be business as usual. I would like also to announce that I have decided to initiate a formal investigation by the Office of the Public Protector into this matter in terms of Section 6, subsection 4, and subsection 5 of the Public Protector Act. It is yet to be clear whether the leak came from the members of the Constitutional Court, the administration within the judiciary, so we will have to also investigate and assist in this particular matter. So insofar as it may have come from the administration, who are employees of the Department of Justice, then the Public Protector has clear jurisdiction. Insofar as it may have come from a member of the judiciary, the constitutional and statutory exemptions contained in Section 182(3) of the Constitution and Section 6(6) of the Public Protector apply respectively. I have therefore been advised specifically to steer away from the investigating relating to court decisions or performance of judicial functions by any member of by any court of law. But then this investigation will strictly be confined on issues of alleged maladministration, corruption, or other criminal conduct. This effectively means that there will be at least 3 separate and parallel investigations in this saga, conducted by the Chief Justice, who announced his investigation last week, the South African Police Services in respect of the complaint I've lodged today, criminal complaint, and the Public Protector South Africa, as explained above. It is therefore important to emphasize that these 3 investigations will largely deal with separate angles of the problem. Although there may be overlaps, it is essential that all 3 investigations must continue with agency. The Office of the Public Protector will cooperate but not interfere with the other 2 investigations. It is indeed difficult to imagine a more serious case than the present one, which involves allegations of illegality to varying degrees on the part of the head of the executive, the legislature, the Minister of Justice, and the judiciary and/or their subordinates, most of which allege illegality is directed against the head of a Chapter 9 institution. In any democracy, and if the allegations are true, they may well signal a total collapse of the state, at best a constitutional crisis of major proportions. The perpetrators must therefore be brought to book and their motives exposed to the public. Otherwise, we will only be dealing with the symptoms of a much deeper sickness in our society. Purely as a matter of courtesy and cooperative governance, the attention of the President, the Minister of Police, and the Minister of Justice will specifically be brought to the actions referred to above. Due to the obvious public importance of this matter, and in the spirit of constitutional values of transparency, openness, and accountability, the statement made to the police and the annexures thereto will be available to the media and members of the public on the Public Protector South Africa website, www.publicprotector.org. Thank you.